Good evening. This meeting will come to order. This is the Milford Zoning Board of Appeals, June 2023 meeting. Let's begin with the Pledge of Allegiance. Thank you. Roll call, please.
Ms. Hirsch and Mr. Wolf are excused. Ms. Ferrante?
Here.
Mr. Dubois?
Here.
Mr. Montano?
Here.
Mr. Soda?
Here.
Mr. Smith?
Here.
And Chairman Tuzzola.
Here. Also present this evening is Stephen Harris, our zoning officer, Meg Green, our recording secretary. If you're here for item number 2, 12 Franz Street, it's been postponed to July, as noted on the agenda for this evening. There's agendas on that table if you'd like to see them. Also, if there's anyone on this commission that might be a conflict of interest to your hearing, please let us know. All right, let's see. So we can begin. Thank you.
Item number 1, 125 Ridgewood Drive, MBP 49/614/3, R10, Kevin Kersaden Esquire for IA Construction, LLC, vary section 3.1.4.1, southerly side yard setback to 5 feet where 10 feet required to construct a new attached garage to existing home.
Okay. You may recall last month that I believe everyone that's here this evening was here for this hearing. It was closed. You weren't? Were you here? Okay, let's check. Otherwise, we'll have Gary fill in for you. That's one other thing I have to do. Mr. Smith is going to be filling in this evening for our member, Chris Wolf. Okay, Mr. Smith, thank you. All right. All the commissioners that are here this evening were here for item number 1 last month, so this is going to be a vote only. So try and think about what we discussed last month, and we need a motion on this. Okay, we just need a motion for a vote. I don't think we can't review this at all, so.
Mr. Chairman, the vote would be in favor with a yes to the applicant.
We have a motion. Do we have a second on the motion?
Can we clarify the motion? I don't know that there was a motion made.
Mr. Chairman, all motions are in the affirmative.
I make a motion to approve.
We need a second.
Second.
We're going to have discussion once we get a second.
Sir.
Oh, you did. I'm sorry. Okay. All right. A motion to approve, and we have a second. Discussion.
Joe, my feeling on this is they've already got the two-car garage in the back, and the neighbors were against it and stuff, so I don't think there's a hardship here.
Any other comments?
Mr. Chairman, from what I've been told and read, the work that this owner is doing, that drainage would be better, and there's, to my understanding, no issue with a single story.
Anything else? Okay, we have a motion to approve, and we have a second on the motion. Mr. Montana?
Go with the motion.
Ms. Ferranti?
With the motion.
Mr. Smith?
With the motion.
Mr. Soto?
Against the motion?
I'm against the motion. Okay, motion fails.
Item number 3, 25 8th Avenue, MBP 9/102/9, R7.5, Robert Maslin Esquire for S. Swan Laurel Beach Association and E.T. Krolikowski III appellants. Appeal the decision of the zoning enforcement officer in accordance with the provisions of section 9.2.1 regarding certificate of zoning compliance for use of land or building, certifying each of the existing developer lots, lot numbers 23, 24, 25, and 26, as shown on maps R33 and F580 are legally non-conforming lots of record.
Good evening, everyone. My name is Robert Maslin. I'm the attorney for the appellants, I guess you'd call them, in this.
Can you you started to adjust your microphone as close as you can with the microphone and up higher.
Like this? Okay. All right.
Thank you.
Okay. My name is Robert Maslin. I'm the attorney for Laurel Beach Association, Ted or E.T. Krolikowski and Suzanne Swan, who are the applicants or the appellants here in this proceeding. Mr. Shanley is here. I think you've seen him before. He's in the front row behind me. He's really here to answer any questions you might have of him on behalf of the association. Mr. Krolikowski, who is going to speak, is sitting in the second row directly behind Mr. Shanley, and Ms. Swan is home ill, couldn't make it to the meeting tonight. This is an appeal of the zoning officer's issuance of a certificate of zoning compliance determining the status of 4 lots that were shown on old maps that go back to the turn of the last century. We have several reasons that are detailed in our addendum to the appeal form. Some of it dealt with section 6.4.2, which still appears in the zoning regulations, and that's why I addressed all of that, and I have since figured out that that section had been repealed, and I was able to figure out the status of the moratorium. The property has been in the R12.5 zone for many years. Obviously, as you probably know, there's a 12,500 minimum square foot lot area requirement, minimum lot width of 80 feet, and lot depth of 100 feet. Before I get into my reasons for reversing the decision here, I would just note that as I had a foot out the door from my office in Darien to come up here, I thought I'd take one more look at the website and found a submission of over 160 pages that the attorney for the property owner had submitted. I haven't really had a chance to go through that in detail. As I sat here before the meeting, Mr. Harris handed me a memo, several pages of his position. I haven't really had a chance to digest that, so I'll do the best I can with what we have. so far. The reasons for reversing the decision are as follows. There has definitely been a merger here. What I was able to glean from skimming through these two submissions that I just mentioned, there's a tendency to treat the declaration of merger, which is in our appeal papers, as if it were just a restrictive covenant. It's not. It's in part a covenant, or a restriction rather, that Mr. Krolikowski has his own ability and standing to enforce, as well as the Laurel Beach Association. But it's also conduct of the property owners that demonstrate an objective or a desire to merge these lots into one. That's not just a restrictive covenant issue. That's a zoning issue because it's conduct consistent with merger, and it is in fact a merger. The declaration contains the following language, quote, in paragraph 4, "It is our intent and desire by this declaration as the owners of the premises to declare for all future time and for all purposes that the premises known as 25 8th Avenue, Milford, Connecticut, shall be considered one parcel of land for all purposes." And then it goes on to say, in the operative, that's just the background section, in the operative language, the two declarants, Mr. Krolikowski and Mr. Minotti, quote, "declared that lots 23, 24, 25, and 26 on the plan of Highwood, Laurel Beach, Milford, Connecticut, as amended by map of March 1930, less the premises conveyed by warranty deed," and I'll talk about that in a second, "are merged." So there really is no question that these four lots have been merged. As I mentioned, the declaration itself vests Laurel Beach Association with standing to enforce the declaration. And of course, Mr. Krolikowski and the other person, Mr. Minotti, still retain the right because it's not an exclusive vesting of enforcement rights. The declaration of merger was recorded on the land records immediately preceding the deed into the current owners, the Doyles. And as a closing attorney, what most likely happened here was the seller's lawyer delivered to the buyer's lawyer a stack of documents that included the declaration and the warranty deed. And whoever recorded those two instruments were instructed to record the declaration first. That means that the current owners took title subject to the declaration. Mr. Krolikowski is here to tell you about his dealings with Mr. Doyle and Mr. Doyle's awareness of this declaration, and he'll also tell you about the listing when he and his co-owner listed the property for sale. There was mention of the intent to merge the properties in the listing, so this is no surprise to the Doyles. In addition to the declaration, I have attached to the appeal papers a set of zoning documents that date back to 1973 by a prior owner. And in that, you'll see a diagram of the entire lot as a single lot with a setback line that shows a side yard setback of 127 feet from the eastern property boundary. That as well is evidence, and it's an independent evidence of an intent to merge the property by the prior owner. Now, I understand that Section 6.4.2 has been repealed. What I'm not understanding is where is the authority for a property owner in a situation like this, where you have 4 lots side by side that have always been owned by the same owner and are now non-conforming, to come into zoning and get a zoning permit. Section 6.4.1 allows that process when the owner of the lot in question and predecessor owners never owned adjoining land. But there's a moratorium on that. But that's not our situation here. So when the Planning and Zoning Commission repealed 6.4.2, they took away the ability to issue a zoning permit for a non-conforming lot under circumstances where the owner owned adjoining lots without applying to the ZBA for a variance. I'm still not sure. Maybe we need to go to court and have a judge figure this out. But that's my reading of the repeal of 6.4.2. Now, in addition, Lot 23 today is not the same as it was in 1901 or during any of the other earlier maps through about 1940, as I understand. After I was able to just take a glance at the 160-plus page submission, I uploaded a copy of a deed that's actually referenced in the property description that's attached to the declaration of merger. And it's a deed from Philip and Norma Gerlach, Gerlach, to people William and Joyce Walsh. The Gerlachs were prior owners of these 4 lots. And what they did in this deed in 1976 was they conveyed out a 20-foot portion of Lot 23. So today, Lot 23 is not the same as it was on those earlier maps. So the zoning officer just, it's an error. It's probably because the zoning officer wasn't aware of this deed, didn't have a current survey, which would have showed the reduced size of the lot. But that's another reason for reversing the zoning officer's decision. And there's another section that I just wanted to mention, and then I'll get to some legal points. Section 2.6. Section 2.6 says, in essence, if you have a non-conforming lot, because of a change in the regulations, you have 5 years to build on it before you have to make it comply. And that 5 years has long since passed. And I would just mention that the property was first zoned, I guess, for the first time back in the 1920s. We're way beyond the 5 years. At least as early as the 1970s, this was still an R12.5 zone. So the legal points I wanted to make: merger can be determined by a property owner's intent and conduct consistent with an intent to merge. Here, that happened twice. The first time was there's a zoning file that gives, that included a hand-drawn sketch, or obviously with a scale or a straight edge, that shows this as a single lot. The second, as I mentioned, is the declaration of merger. Merger does not require a map to be recorded showing merged lots as a single lot. Conduct is sufficient. The declaration of merger is more than sufficient to document the merger of these 4 lots, or what's left of them. And finally, once lots have merged, you can't unmerge them. That's in the case law. It's mentioned in cases involving the Milford ZBA and Laurel Beach Association. It's a basic premise of zoning. Once lots have merged, you can't unmerge them. If you can create complying lots from a merged property, that's one thing. You go to the Planning Commission or the Planning and Zoning Commission, depending on what you have in your municipality, and you do a subdivision or a re-subdivision application. Or if you qualify, you get a first cut directly from the town planner. But the zoning officer is not a planner, the town planner, as he acted in this particular situation. And as I mentioned, you need a subdivision or a re-subdivision application. So those are my points. I'm still going through these documents that have been submitted at the last minute, and if I have an opportunity to come up when the other...
Can I
speakers
interrupt you
are
for 1 minute
finished,
then?
I'd appreciate
You've
that.
stated that a few times, that you seem to think that you're missing some information. Do you want to go forward with this evening?
If we can continue it so I can digest all of this and prepare a written response, I think
that would be entirely up to you if you want to continue this to next month. You know,
I'd like
you've mentioned a few times you're not prepared, so.
I'd like to do that if it's okay with you, Mr. Chairman.
We honor all requests.
We
So
can- we
if
can-
you don't feel you're prepared, you know, we want to be fair with everybody, no matter what the hearing is. So,
Understood.
you know, if things don't go the way the applicant wants it to go, then, you know, that would be one of the reasons that they weren't prepared.
No,
So-
fine.
So that would be your decision. If you'd like to have us continue it, we will do that.
Yes, I would like to do that. What I could suggest, though, is if you want to continue with tonight's session and then hold the hearing open, that would be fine with me as well. That I'll leave up to you.
Okay, how's the board feel on this? Anybody have any statements on what they want to do?
I'd like to stop it here, Joe, and just hear everything next month so it's all fresh in our heads, too.
Mr. Chairman, if I may, both sides have prepared remarks. I would urge the board to let both parties, or all parties, have their say this hearing. And if you want to continue it to July, you can do that.
Of
Yeah, but
course,
how,
of course.
Stephen, how can he give us his presentation when, I mean, I saw the email came in at 4 o'clock with 100 and something pages too. And I mean, I scanned through it quickly, but I didn't absorb it either.
Well, by holding the hearing open, then the appellant can fill in the gaps in his presentation next month. In the meantime, the city's position and the property owner are here tonight, and I would like to be heard tonight.
I have no preference one way or the other. If you'd like to hear from the other folks who are here,
Do you want to ask your client or the people that you're representing if they're in favor of leaving it open? Because I'll leave it open. The city, of course, they haven't had their opportunity to defend themselves, but we haven't gotten to that point in the meeting yet. So
right.
if you want to check with the people that you're representing, if they want you to move this to next month, we'll do that.
May I have a moment?
Sure.
Yes.
All right, you want me to leave this open and we'll
Leave it
continue?
open till next
And we'll
month.
continue it, okay. Do we have to take a vote on this, Stephen, or I'll just leave it open?
And not until you're ready to actually keep it open.
We're just keeping it open.
Will I get a chance to speak? Will the property owners council and myself get a chance to speak tonight?
Why would they speak? Why would the property owner speak right now?
Well, everybody who has an interest in this has a right and an opportunity to speak. The city certainly does, and the property owner, who's represented by council tonight, also has a right to be heard.
Okay, well, we're
Because
still going to leave it
the
open?
appellant- the
We're going to
appellant
hear
started-
these other people, but we're still going to leave it open, correct?
Yes.
Okay.
I think it's only fair because the
All right.
appellant's attorney has offered testimony.
But when we do that, then we're going to have bits and pieces next time we meet.
It's not unusual when a hearing gets left open for more information to be offered at the second hearing. That's the reason why it's left open.
I have no issue with proceeding in that way either, Mr. Chairman.
Okay, we're going to proceed.
All right. Okay, sorry, continue
No,
on.
no, that's okay. As
I just
long as-
wanted to give you the opportunity, because you had stated a few times that you didn't feel prepared.
I really appreciate that.
Sure.
And thank you for that.
We'll move
and-
forward with it then. Thank you.
And then we'll be back next month, and what I usually would do is just reply to the new comments in the two submissions, and it wouldn't be a rehash of the whole thing again.
Well, we might have a judgment on it this evening if we're going to move forward right now.
Well,
Okay, all right.
my understanding was
All
that
right,
you-
okay. Yep, you're right.
Okay, all right.
We're going to keep it open, but we're going to let people
Sure,
talk this
thank you.
evening. Okay. All right, who else is speaking on this appeal that wants to come forward this evening?
Mr. Chairman? Mr. Chairman, it's customary for the city to respond after the appellant in appeals.
Yes, of course.
Good evening, Stephen Harris, Zoning Enforcement Officer. I'm going to read a prepared statement into the record. Board members and both councils also have a copy of this. So, summary of facts and procedural history. On May 21st, 2021, the Planning and Zoning Board repealed Section 6.4.2, use of non-conforming lots when applicants or a predecessor owned or owned adjacent land. On July 15th, 2022, the Planning and Zoning Board enacted a moratorium on lot certification. The moratorium expired November 30th, 2022. On March 31st, 2023, prior to enactment of a second moratorium, an application to certify lots 23 through 26 at 25 8th Avenue was received, and that was PL, this is the file number, PL-23-0025, with the following documents in support thereof. A warranty deed dated September 21st, 2016, and recorded September 29th, 2016 in volume 3701, page 402 of the Milford Land Records. B, City of Milford, Connecticut, assessment parcel map ID 398, address 25 8th Avenue, dated December 2021. C, amended map of Highwood, Laurel Beach, Milford, Connecticut, May 1925, on file in the Milford Clerk's Office as map number R33. And D, second amended map of Highwood, Laurel Beach, Milford, Connecticut, March 1930, on file in the Milford City Clerk's Office, map number F580. On April 4th, 2023, the Planning and Zoning Board enacted a second moratorium concerning lots created prior to the adoption of subdivision regulations that do not conform to current regulations. This moratorium expires August 31st, 2023. On April 20th, 2023, upon review of application PL-23-0025 and documents submitted in support thereof, certificates of zoning compliance were issued for lots 23 through 26 at 25 8th Avenue. On May 8th, 2023, the property owner placed a legal advertisement in the New Haven Register noticing the issuance of certificates of zoning compliance. On May 18th, 2023, an application to the Zoning Board of Appeals was received appealing the issuance of the certificates of zoning compliance for use of land or building, certifying each of the existing developer lots, lots 23, 24, 25, and 26, as shown on maps R33 and F580, are legally non-conforming lots of record, together with the following documents in support thereof. A, declaration of merger of lots dated September 20th, 2016, and recorded September 29th, 2016, in volume 3701, page 398 of the Milford Land Records. And B, application for approval of zoning compliance dated October 3rd, 1972. The appeal was timely filed. City's position. 1, doctrine of merger. Traditionally, under the doctrine of merger, contiguous lots owned by the same entity may merge into a single lot either by operation of law, by local regulation or ordinance, or by use. Use of lot indicates the owner's intent to consolidate them into a single unit. On May 21st, 2023, the Milford Planning and Zoning Board repealed Section 6.4.2, which was a merger by use regulation. The Milford zoning regulations do not have merger by operation of law. As such, the city does not have a merger rule, and thus the lots in question are not considered merged and may be certified as legal pre-existing lots of record. In support of their appeal, appellants provided a declaration of merger dated September 20th, 2016, and recorded September 29th, 2016 in volume 3701, page 398 of the Milford Land Records. The declaration provides as follows: lots 23, 24, 25, 26 on plan of Highwood Laurel Beach, Milford, Connecticut, as amended by map of March 30th, less the premises conveyed by warranty deed of August 25th, 1976 at volume 862, page 273 of the Milford Land Records, are hereby declared merged, and that their individual existence as separate lots, parcels of land, as shown on said map, referenced above, is hereby terminated, extinguished, and of no further legal effect for all purposes. As such, the subject property shall be used as the location for one single-family residential dwelling and for a swimming pool if one is installed at any point in the future from this day forth. Neither the enabling statutes nor the Milford zoning regulations authorize the Zoning Board of Appeals to adjudicate private deed restrictions. I'll read that again. Neither the enabling statutes nor the Milford zoning regulations authorize the Zoning Board of Appeals to adjudicate private deed restrictions. 2, moratorium regarding section 6.4. The appellants state, quote, "The Planning and Zoning Board has placed a moratorium on section 6.4 of the zoning regulations. The moratorium will remain in effect until August 14th, 2023, ellipses. There was no legal basis for the zoning enforcement office to issue a certificate of zoning compliance," end quote. A moratorium concerning lot certification was enacted by the Planning and Zoning Board on July 15th, 2022, and expired November 30th, 2022. Thereafter, on April 24th, 2023, a second moratorium was enacted by the Planning and Zoning Board concerning lot certification. The second moratorium will expire August 30th, 2023. On March 31st, 2023, after expiration of the first moratorium and prior to the enactment of a second moratorium, application PL 230025 requesting certification was received. No moratorium was in place when application PL 230025 was received. 3, certificate of zoning compliance, 1972. The appellants state, quote, "On or about October 3rd, 1972, a prior owner of 28 8th Avenue filed an application for zoning approval of zoning compliance. That application included a drawing that characterized the subject property as a single parcel with side yard measurement. The drawing confirmed the merge of the previous development lots. Notably, section 6.4.2, parentheses 3BE of the zoning regulations provide that such characterization merges the parcel into a single lot," end quote. Section 642 did not exist in 1972. Furthermore, section 642 was repealed May 21st of 2021. Conclusion: the Zoning Board of Appeals does not have the authority to adjudicate private deed restrictions. 2, the application requesting lot certification was received subsequent to the repeal of section 642 and during the window of time when there was no moratorium on lot certification in place. 3, the application for approval of zoning compliance dated October 3rd, 1972, and subsequent certification of zoning compliance issued June 14th, 1973, are not evidence of merger, as section 642 had not been enacted at that time. And I would just like to add, this is not in the written remarks, that the plan referenced in 1972 is not a survey. It does not tell us its providence. For all intents and purposes, they're just lines on a map. We have no idea where they came from. And that plan does that, actually that zoning application to add onto a garage does not indicate anywhere on that paperwork that it is a lot merger. Getting back to my prepared remarks, number 3, the application for zoning approval, I read that one. So in conclusion, for the reasons set forth herein, I respectfully request the board uphold the certificates of zoning compliance for lots 23 through 26 at 25 8th Avenue. That's the end of my prepared remarks. I would also like to add that the appellant mentioned 641 as being operative. Again, the last couple of months we've had these merger questions come before us. And just to remind the board, the old section 642 involved multiple lots owned by a single entity. Section 641 involves a single parcel owned by an entity, where none of the surrounding parcels are also owned by the same entity. So 641 is completely not germane. If you have a single standalone lot, for instance, if I own it, I own no other abutting lots, then 641 could come into play. But if I own this lot and the immediate abutting lot, then the old 642 would have come into play. So 641 is completely not germane to this argument. And I will be happy to answer any further questions.
All right, questions? Mr. Soto, go ahead.
So Stephen, a couple months ago, we had 4th Avenue with the 3 lots.
Yes.
This is the exact same situation, correct?
Yes,
So basically, we have no jurisdiction over this.
yes. As I read in my prepared remarks,
Right.
that the Zoning Board of Appeals does not have any authority by statute or by the zoning regulations to adjudicate deed restrictions.
Go ahead, Mr. Smith.
If we don't have jurisdiction, why is it before us today? Is it just a quirk in the statutes? Is it why, if we don't have jurisdiction on this, how come this application is in front of us? Is it just the process they have to follow?
Anybody anybody who's aggrieved can appeal any order, decision, or requirement of the zoning enforcement officer.
Okay, thank you.
Any other questions? All right, are we going to let anyone else speak on the upholding the decision that you've made? Anyone else want to speak on upholding? Mr. Crusaden?
Good evening, Mr. Chairman. If there's going to be further public comment tonight, I'll just reserve my time for next month. I don't
Okay.
wanna- I don't know if anyone else is going to speak. If not, I'll give my presentation now.
Okay, we're going to continue this, right, Mr. Harris? We're all set, we're just going to continue this.
That's up to the board.
Yes, okay, we'll take a vote on it. All in favor of continuing? Okay, all right, this hearing is continued to July 2023. Do we have a date for the July meeting? July 11th.
Thank you very much.
You're welcome.
Okay, item number 4, 20 Hanover Street, MBP 22/458/7, R5, Elias Kutikas owner, varies section 3.1.4.1, west side yard setback to 5 feet where 10 feet required, 4.1.4, west side deck projection to 5.34 feet where 8 feet required, all to construct single-family residence.
Okay, also read in.
Mr. Chairman?
Read in number 5.
Mr.
Yes.
Chairman, can we take a few minutes
Sure.
to see if we can reconnect these screens here?
Okay.
For some reason, they've gone dark, and I don't know why. Maybe there's a connection down there. I don't know.
I had, yeah, but I can just represent it for the record. Right. it's definitely a connection problem because it's on the right input. It's on the right put. All right, well, I can do this.
All right, we're gonna do 4 and 5 together. So let her read in 5.
Item number 5, 22 Hanover Street, MBP 22/458/7, R5, Elias Kutikas, owner, varies section 3.1.4.1, west side yard setback to 5 feet where 10 feet required, 4.1.4, west side deck projection to 5.25 feet where 8 feet required, all to construct single-family residence.
All right, and thank you, Mr. Chairman. Just for the record, again, Thomas Lynch from the law firm Lynch, Trimbicki, and Boynton. My office is located here in Milford at 63 Cherry Street, and I'm here tonight with my client, Leo Kutikas. Where we left off, if we recall from last month, there was comments from the neighbors as to their acceptance of the 20-foot wide house, but the concern was the second variance that we were requesting for the rear deck. So we revised the plans. They've been submitted to you. They were on the screen a second ago, and they're gone. So hopefully you can share the paper copies or follow this on the your iPhones, or look up there every once in a while, and it'll show up. But the bottom line is, we've revised the plans. The deck is now conforming with the rear yard setback requirement. There is the projection on the west side variance still because it follows the length of the house back for the 7 feet. But the plans were revised. The deck is now substantially conforming, and I think that's where we left off last month. So unless the board has any other questions.
Mr. Soda has a question. Go ahead.
So how much did you reduce these decks by? How many feet?
3 feet.
3 feet?
Yeah.
So this is correct. It's 10 foot now from the rear?
There's 7 feet.
7, okay.
7 by the width of the house, 20.
Any other questions? We all know what's going on, right, by our plans, right? Okay. All right. Was there anyone else speaking in favor?
Hi, my name is Tim McFadden, and I'm here on behalf of Leo. Just say he's a great neighbor, owns one of a business.
I'm sorry, Mr. McFadden, can you give us your address, please?
I'm sorry?
Your address?
10 Cooper. So I'm right behind the Greek spot. Leo's great for the community. He's been a good person and a good family, and we look forward to him getting this approved. Thank you.
Thank you, sir. Anyone else speaking in favor? Anyone else speaking in favor? Is there anyone here opposed? Anyone opposed? Any further questions? Board, no? Okay, this hearing is closed.
Mr. Chairman, we're taking both of these together, right?
Yes, yes.
That means
They
separate
were
votes.
both read in.
Separate votes for each.
They were both read in. Okay, sure. All right, we need a motion for number 4.
I make a motion to approve.
Second.
We have a motion to approve, and we have a second on the motion. Discussion? No discussion? We're all set? Okay. Mr. Montana?
Approve.
Ms. Ferranti?
With the motion.
Mr. Soda?
With the motion.
Mr. Smith?
With the motion.
I'm with the motion. It's approved. Item number 5. We need a motion, item number 5.
I make a motion for 22 Hanover to approve.
Second.
22 Hanover, we have a motion to approve, and we have a second on the motion. Mr. Montana?
Approve.
Ms. Ferranti?
With the motion.
Mr. Smith?
With the motion.
Mr. Soda?
With the motion.
I'm with the motion. It's approved.
All right, thanks so much.
Item number 6, 14 Loomis Street, MBP 19/203/13, R10, Thomas Lynch Esquire for 14 Loomis LLC, owner, varies Section 5.1.9 to allow parking area to serve Doyle Funeral Home located at 3 Loomis Street in a residential zone.
Thank you. And again, Mr. Chairman, just for the record, Attorney Thomas Lynch. On this application, I'm representing 14 Loomis Street LLC, who's the owner of the property at 14 Loomis Street. I'm here tonight with the principal of the LLC, Mr. William Britt. Mr. Britt is also here with his daughter, Mariah Monsi, who is the funeral director for the Doyle Funeral Home. They have owned the funeral home property for over 72 years. Mariah's grandparents started this funeral home, the Doyle Funeral Home, back in, I believe it was 1951. She is a third-generation operator of the business, and especially with the purchase recently of the last year or so of the Smith Funeral Home, the Doyle Funeral Home is the only family-owned funeral home left in Milford, and they do a wonderful job handling families during times of need. And anyone who has gone to services at the Doyle Funeral Home know that parking is a major problem. 5 Loomis Street is the property that's owned and by the family as well, and that's where the funeral home operates. On site at 5 Loomis Street, there's approximately room for 22 cars for parking. So if you have a service or a wake of any substance or of any magnitude in terms of folks coming out to pay respects, if you've been there before, you know the cars park all the way down Loomis Street, and it creates a lot of anxiety and some anxious moments for residents when they have to put up with that. So last year, Bill purchased the property directly across the street at 14 Loomis Street. That property had a dilapidated small residence located on it. It's approximately 1,200 square feet. It was built back in the 1920s. There was also a dilapidated garage to the rear of the residence, and that's been demolished. So if we can get the plans on the screen, and if not, if we can pass them along. We did submit a site plan that was prepared by Westcott and Mapes to you. The intent here is to utilize the easterly side of the property for a parking lot to service Doyle Funeral Home only. It's not going to be a commercial parking lot that's going to be available for any other use. It's for the Doyle Funeral Home only. The residence that's located on the site is also going to be renovated, so the residential use is going to be maintained. So one of the nuances under our zoning regulations is, if you look at section 519 of our regulations, you can only have parking lots in areas where the zone allows parking lots. You can also have off-site parking. In other words, if an individual owns one piece of property, as long as he owns another parcel within 250 feet measured distance from the first parcel, which is the case here, because the two properties are right across the street from each other, then the zoning regulations as they relate to parking lots allow that off-site usage of the other property. However, it can only be used in residential zones if the use of the parking is allowed in a residential zone. And the nuance that we have here is that the property at 5 Loomis Street is located in the CDD2 corridor zone on Bridgeport Avenue. The property at 14 Loomis is located in the residential zone. So that's why we're before you tonight with this request for a variance. It's to allow that other property to be maintained as a residence, but also to provide some 24 additional parking spaces to service the funeral home. And we do have a site plan, as I mentioned, that Westcott and Mapes has put together, and it's on the screen now. So you can see the improvement that will be made on the easterly side of the property, maintaining the residence. A new garage structure will be built to the rear of the property. But again, under the regulations of 519, there'll be required screening, fencing, marking of the parking spaces. So all of the requirements of that section of our zoning regulations will have to be met. And in reviewing the regulations, in fact, this would require a site plan review by the Planning and Zoning Board, as well as the variance that we're seeking here tonight. This is a use variance. It's a little different than what you're normally hearing when we bring applications to you. And under Section 519, as I mentioned, this is to allow the residential zone to have a use that is not permitted in the residential zone. But another section of our regulations, Section 9.2, allows use variances, and I'm quoting from the regulation. They're allowed if they are not detrimental to community, public health, safety, and welfare. And I submit to you tonight that that's exactly what we're looking for here, is to actually increase public safety, to address the fact that on that narrow street there are many cars sometimes parked on both sides of the street during services at the funeral home. This is going to alleviate that. It's going to take 24 spaces or cars off of the street. And I submit to you that that is exactly what Section 9.2 of our zoning regulations allows the board to entertain and also to grant. So again, just to summarize things, the residential use is going to be maintained. There was initial discussions that I had with David Sulkus when he had floated the idea of actually applying for a zone change, because 14 Loomis is one parcel back from the zone line on the CDD zone on Bridgeport Avenue. But my clients have spoken to neighbors, and they were sensitive to the fact that if we sought a zone change, then any commercial use could take place on 14 Loomis. Here, we're asking for a specific use variance. We're only asking for this property to be used for parking for Doyle Funeral Home, not to create a situation where the zone line is brought down and a new commercial parcel is created that could have a retail or a Dunkin' Donuts on it 2 years from now, and then the neighbors would really be upset. So that was the purpose of, in my discussions with David, I said to him my client felt it was more appropriate to do a use variance under this application, and it allayed fears of the neighbors. I also want to submit to you, I spoke to Mr. Britt before I started my presentation. He has spoken to neighbors. Everyone that he had spoken to said that they were in favor of this. He didn't have people write letters or send emails in, but I can represent to you that Mr. Brett, with the family owning that property for so many years and knowing all the neighbors over the years, they did their due diligence to go out and communicate to neighbors as to what they wanted to do with this application, and all of the neighbors seemed to feel that it was acceptable to them. So with that, I'm happy to answer any questions you might have, and I think this is going to be a real great thing for the area in terms of alleviating a bad parking situation.
Commissioners, any questions? No? No? No questions right now. Anyone else speaking in favor? Anyone else speaking in favor? Come forward, please.
Hello, my name is Randy Jackson. I live at 97 Loomis Street. I'm not exactly a neighbor, I'm a couple blocks down, but I can attest to the safety aspect. A couple decades ago, we were in the habit, the person I was living with at the time, when she would come home from work, I would call and say that there's a service at the end of the street, drive around the block and avoid it. It is a bad traffic situation. The funeral home, more than a decade ago, changed some of their plans, and they put signs out to prevent people from parking right near Route 1. But often people will still park there, and the bereaved will actually sometimes stand in the street and talk to each other. So when you drive off of Route 1, you'll find all of a sudden there's a couple people who are not paying attention to traffic, who are then standing in the street and interacting with each other. It's not an ideal situation. Having some additional parking would also be great to alleviate the parking situation, because it continues down not just the block, but when there's a more popular deceased, shall we say, people end up driving down the residential area around the further blocks and parking in that area as well. So that is why I'm in favor.
Thank you for your comments.
Thank you.
Anyone else speaking in favor?
Hello, my name is Leo Koutikas. I live on 743 East Broadway. I own the Greek Spot Cafe on East Broadway also. I understand about parking. It's very difficult. Anybody who owns a business and doesn't have parking, it's very hard. So if someone who owns a business is looking for some parking, I think you should give it to them. They need it. Thanks.
Thank you. Anyone else speak in favor? Is there anyone here opposed? Anyone here opposed? Any further questions? Okay, this hearing is closed. Need a motion to approve?
Make a motion to approve.
Second.
We have a motion to approve. We have a second. Discussion?
It's a no-brainer. They need the parking.
I think it's a great plan. I like that they're going to be retaining the residential use of the lot. I think it's a great compromise. I see the hardship. It's a unique situation. I think it's great.
Yeah, it's only enhancing the neighborhood. So, Mr. Smith?
With the motion.
Mr. Soto?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Montano?
With the motion.
I'm with the motion. It's approved.
Item number 7, 128 Beach Avenue, MBP 60/743/11, R7.5. Thomas Lynch, Esquire, for Mervyn Klein, owner, vary section 4.1.1.1, proposed pool front yard setback from Blackall Road to 12.5 feet where 20 feet required, and proposed pool equipment storage front yard setback to 7 feet where 20 feet required as part of new residence construction.
Thank you, Mr. Chairman. And again, for the record, Thomas Lynch. On this file, I'm representing Mervyn and Faye Klein. My clients recently purchased the property at 128 Beach Avenue, which is located in one of the nicest spots in town, I think, right at the curve at Anchor Beach with the flagpole. They bought this property last year, and they are going to do a complete rebuild of the single-family residence that's located there. So I'm here tonight with Peter Cooper from Greenwich. Mr. Cooper designed this beautiful house. We have some pictures to show you after I just talk about briefly the site plan. But the house itself is going to be constructed within all of the setbacks, so that there is an existing detached garage that a second floor is going to be placed over, where there's going to be a recreation room. The height will be 15 feet to the midpoint, so that it meets all the zoning standards. The garage itself currently is non-conforming, but it's being built up from this current footprint, so there's no necessity for variances for that. So the application that's before you is to vary section 411 when you have accessory structures within the setbacks, and that's the case here because, very simply, we have 2 front yards on this property. The property fronts, the main frontage is on Beach Avenue, and Blackwall Street is to the rear of the property. Blackwall does not carry much traffic. I don't even know if it completely carries through to Village Road or not, but the main thing is the pool that's shown on the plans and the pool equipment are going to come, the pool itself is going to be 12 feet 5 from the setback where 20 feet is required. The equipment is going to be 7 feet where the setback is required for that. So again, this is a 3,300 square foot house that was built in 1925. It's going to be completely renovated. We had pictures on the screen, but here they are here, so you can see this beautiful house that Peter's designed. It's actually spectacular. It's going to have the improvement over the garage. It's going to have a wraparound porch. It's going to have sort of a gazebo end to one area of the porch, and then the pool will be on the westerly side of the property along with the equipment, and that's where we're seeking the variance. The hardship is clear here because of the fact that there's 2 front yard setbacks that we have to meet. I appeared before this board 3 years ago representing Fred and Lisa Serra, who did a major renovation to their house next door at 124 Beach Avenue, and this board did grant them their variances. There was an email that Mr. Sarah sent to me, and I forwarded it to Meg to upload to your agenda. That they are the adjacent property owners on that side where the garage is going to be built, and then the pool is on the other side, but they sent an email saying that they're in full support of this application. So with that, we can answer any questions that you may have, but again, this is going to be a beautiful, beautiful new home, and the substantial improvements, the house itself, are all going to be built within the setbacks.
Questions?
Mr. Lynch, you said that the hardship is that this property has 2 front yards. However, the front yard setback in an R75 is 20 feet, and the rear yard setback is 25. So the uniqueness of this property having 2 front yards actually gives your clients more space to do with what they will, and yet you're still requesting a variance. So I'm really not sure what the hardship is.
The hardship is that there's 2 front yards setbacks that we have to meet. I understand what you're saying about a rear yard setback, but that doesn't apply if you have a front yard on Beach and a front yard on Black.
If you had a rear yard setback, you would be even more restricted than this property currently is. You have to have some setback. The fact that this property has 2 front yards gives your client more space to build within setbacks, or with respect to setbacks. So I don't see the hardship.
Well, I disagree with you, but that's...
Mr. Soto.
Mr. Chairman, if I could clarify what the regulations say.
This is for an accessory structure, Sarah. It's not the building itself. This is a variance of 411.
Yeah. So the regulation that they're asking to vary isn't the regular setback. It's the setback for an accessory structure, which can't be in the required front yard.
I apologize, I was looking at the old.
I get it.
Okay, I have the new one here.
Do I need to maybe make that a little bit more clear to everybody? In other words, section 411 of the regulations say that you can't have any accessory structure within the setback. So whether the setback is 20 feet or what Sarah's saying is a rear yard setback, but you can't have an accessory structure within a setback. This is a request to vary that. And what I'm saying is because it's Blackhall and it's the rear portion of the property with no traffic, it's not really an infringement.
Yeah. Mr. Chairman, I can just read the regulation that they're asking to vary. Section 4.1.1, it reads, no structure or accessory building shall be located in any required front yard.
So is that a front yard where it is?
Meaning, and a pool is an accessory structure.
And it is a front yard because there's 2 front yards.
Well, Stephen, in your opinion, what does required mean?
Pardon?
In your opinion, what does required mean?
The required yard is the setback. So in other words, the setback, the front yard setback is 20 feet. So an accessory structure like a shed or a pool can't be located within the required setback. So the thing just went off again. So the pool has to be set back at least 20 feet from Blackhall Road. They're asking to be inside that.
No, I understand that. Never mind. Okay.
Yeah, go ahead, Mr. Soto.
Attorney Lynch, so we know the pool will have a fence around it by regulations, that's required.
Oh, yeah, and it's going to
How
have
about
shrubs, too, yeah.
Okay, how about the pool equipment? How are you going to disguise that? Because that's going to be closer to the road.
I think Peter has it on his plans. There's going to be fencing around and then shrubs around
Okay.
it. Yeah.
Okay.
Also, could that pool have been moved in a little further?
There's a patio, right?
It would encroach.
Here, come on.
Please identify yourself.
Peter Cooper, architect and landscape architect.
Yeah, the question is the size of the pool, too. Could that have been moved in? I see the proposed patio.
So the main concern was how close it would end up being to the house. I think that was the primary concern. Mrs. Klein likes to do laps. She's in her 60s, but she's active, and so the length of the pool was the driver for that. As the pool moves closer to the beach Ave, it would then start to encroach on the house, and that was seen as not as desirable. We feel the pool is going to be barely seen. There will be both evergreen hedgerow, and there'll be buffer, so it will be really not visible for all practical purposes from both side and from Blackball Road. And if one considers the fact that the garage itself is also non-conforming and considerably close to Blackball, the pool sits back somewhat further from that. And the fact that it is a horizontal service, I would suggest it's not going to have any negative impact to the neighborhood.
All right, so it is a lap pool, and it is 42 foot long. So that is one of the questions I have, is maybe the pool could not be 42 foot long. I know a lap pool can be even a minimum of 30 foot.
I could speak on behalf of my client. Perhaps some compromise is in order if the board felt strongly, but it's hard for me to speak without their being present. If the board felt that some reduction were appropriate, then I would follow that request. I don't know how the board wants to handle that.
Well, you know, you've done an excellent job of proposing everything else to fit in here, and it's just this one thing, actually, is the pool and the storage unit that is in the back there. It's 7 feet from the property line in the back. So
The pool equipment, Joe, is 7 feet. The pool itself is 12.5.
the pool is 12.5. The structure, the item at 7 foot, isn't that the equipment thing?
Yes.
That could be moved.
I'm looking at a landscape plan, which was an earlier rendition. The site plan.
You got to speak.
The site plan is a formal application. The landscape plan is not up to date. So
By code, does the pool equipment have to be so many feet away from the...
it's good building practice. I don't know of any code that, requires the equipment.
The pool equipment, Bill? Do you know? I just don't know because of the electrical. It may be a code, that may be a code issue.
I don't know if there is. Maybe Joe knows back there.
You know, if a pool...
Is there a requirement for the pool equipment to be within so many feet of a built-in pool?
Gentlemen, try to be near a microphone, please.
Sure. Does the pool equipment, is there a requirement that the pool equipment be so many feet away from the pool itself, either because of electrical conduits or... You're not?
I'm Joe Griffith. I'm the building official for the city of Milford, and no, there is no minimum requirement.
All right, so maybe the pool can move them. Well, we are before you with two variances. It seems as though perhaps the pool equipment we can pull in, and if we did that, is it problematic about the 42-foot pool?
I want to ask the zoning officer a question about that. Mr. Harris, what size pool would fit in there without a variance?
That's a very open-ended question. I mean, you could have a pool that's 10 feet long, or, I mean, there's too many variables to answer that question. It's not up to me to design their house.
Well, I'm just trying to, if we're not in favor of this, it's like, there's got to be a way to fix the problem here.
Joe, if I could jump in, if you take 12 feet off of a 42-foot pool, that leaves 30 feet, and that is an extremely small pool. I have a in-ground pool that's 18 by 36, and it's sort of a standard size pool, and that's not a lap pool. It's a...
I also agree with Joe. I know this was addressed. I think the pool can be moved towards Beach Avenue. All I'm hearing is that doing that is not desirable, but that's not what a hardship is.
All right, why don't we leave this open if we could, all right, and we'll go back to the drawing board and come back with something next month. Is that, the board good with that?
Mr. Smith has a question.
Yeah, so I saw the note from the person at 124 supporting the application. Have you talked to the person at 130, which looks like it abuts the pool?
No, but they got a letter, so they knew we were coming here tonight, so if they had any comment either way, they could submit it. Yep.
Thank you.
Right?
Does the board have any preference or suggestion, or is
We'll
this...
talk.
Okay. How does the board feel about leaving this open? If we see there's room for improvement, or we just move forward with this right now, or what do you think? Mr. Lynch is offering a, maybe a way we can have a better solution to this. Go ahead, Mr. Smith.
Yeah, I think if leaving it open is fine. I don't personally have a problem with the pool, but if they want to leave it open for a month and figure out other options. Yeah.
Yeah, I don't have a problem. I really don't have a problem with the pool, but I'll leave it open.
I'm okay leaving it open.
Okay, we're going to continue this to next month.
Okay, thanks.
Item number 8, 21 Tremont Street, MVP 27/451/10R5, Thomas Lynch Esquire for Beth Vogler, owner, various section 3.1.4.1, side yard setback to 8.8 feet where 10 feet required, rear yard setback to 16.3 feet where 20 feet required to construct addition. Vary 4.1.4 side projection to 1.78 feet where 8 feet required for proposed deck, and rear yard projection to 11.5 feet where 16 feet required for proposed generator platform.
Thank you. And again, Mr. Chairman, for the record, Thomas Lynch on this application. I'm representing Beth Vogler, who's the owner of the property at 21 Tremont Street. I'm here tonight with Beth's sister, Mary Vogler, who came up from New York. And this is an application to allow continued renovation and reconstruction of the house at 21 Tremont Street that suffered substantial damage from both Hurricane Irene and Superstorm Sandy in 2011 and 2012. The request tonight is for 2 variances under section 3141 for the side and the rear yard to construct an addition to the property, and then 2 variances of section 414, the projection section for the deck on the side of the property and a generator platform. And also with me here tonight is John Whitco, who has designed the plans for this house, and he's going to go through some of the specifics of the floor plan and the design that he set in motion here for Beth. So just a little bit of background, as I said, Beth purchased 21 Tremont in 2001. She has submitted, and it was uploaded to your agenda, a letter of explanation giving a brief history of the travails that she's had in terms of having to deal with the damage from both Sandy and Irene, and also dealing with contractors that started to do work and then left. And her letter speaks for itself. But I wanted to focus on the fact that, this is a small lot. It's some 2,810 square feet in the R5 zone. so there's not a lot of land to work with here. The existing structure that was on site was, basically destroyed. Right now, she's started the process of building with having the house raised. There's a lower level with a carport and storage area and utilities, and there was an amount of work that was done, but then it was stopped because, quite honestly, last year, Beth was diagnosed with Parkinson's disease, so she employed John to reconfigure the house to meet her disabilities. So the floor plan that John's going to go through with you has a first floor bedroom on the first living area. Also, the house is provided with an elevator so that Beth can use the elevator to access the house, as well as a deck and stairs to accommodate her handicapped living arrangement. So, the hardship is, again, the narrow lot. The side variances are on the west side of the property, which is the marsh side. I don't know if the board members went down Tremont Street to look at the site. The site's located at the end of Tremont Street. It's a dead end that comes into the, the East Broadway salt marsh. So that the addition was designed to go on that side of the property, necessitating variances, of course, but on the other hand, they're on the side of the property that really isn't going to infringe on any neighbor. I mean, the side yard variance on the west and the deck projection and whatnot is all designed to be on the side of the property near the marsh. The existing house now, prior to the storm, was non-conforming. This is more conforming. It's also been raised to the FEMA elevation levels that are appropriate for this area. So this application seeks to just continue and finish the work to design this house and make it accommodating for Beth as she moves forward with living with a disability. So I'm going to turn it over to John. He's going to hopefully be able to see the floor plans and give you an idea of what he's done to the property. And then if you have any questions, we can address those. Thanks.
Good evening, John Wicko, architect, 58 Prospect Street in Milford. The house actually has a pretty long history. It's been in construction since the storm and the hurricane and superstorm. And we were brought in to really start with the elevator and also other barrier-free renovations, which included the side deck. Right now, it's more of a walkway for egress than it is a usable deck. So we have it large enough for a table and some chairs and some clearance area that could be used with the disability. The physical extension we did out the back to accommodate elevator and access into the house. All of the work in the rear is on the same footprint as that elevated deck that is there now. With the flood hazard being on the site, we are elevating the air conditioning equipment and generator, and the feasible spot for that, which we really need to do, is out the back, and that constitutes the closest area to the rear lot. The elevator, again, it's in the same footprint as the deck that's there, and then the size of the deck is increased to allow use, and we also improve the egress requirement for the door and steps down to the parking area, which are in the same location as where they were, but they're improved. Access to the rear, we are pinching that side yard is primarily through underneath the elevated house. It's up over 13 feet, and speaking with engineers and contractors, we're actually going to use the carport to gain access to set the piles and do the construction. So we considered that when we were laying out the improvements. That's the basic principle and what we've done. The elevator is going up to the second floor as well to gain access to the sleeping and bedroom areas, which we did quite a lot of widening of doors and barrier-free lavatory bathroom that's existing currently. That's the general overview of what the improvements are and the reasons why.
Okay, any questions for Mr. Whitco or Attorney Lynch? Go ahead, Mr. Soto.
Will there be parking under the house?
Yeah, there's space for two
cars,
comfortable cars, and there's a driveway too, small. So, yeah, that's improved with the raising of the house some years ago.
Other questions? Mr. Montana.
John,
Yeah.
the elevator, 4 stories, ground, and then 3?
It's ground, first, and second, so 3 stops.
Nothing to the 3rd?
Well, I guess, yeah, first ground floor and then first and second floor.
Okay.
So that's just 3 stops.
Because I see bedrooms, but it says 3rd floor.
If you consider the ground floor the first, it would be 1, 2, 3.
Where the cars park would be ground floor,
Yeah.
then 1, 2, 3?
No, then 1 and 2. Then so
Okay.
that's mislabeled if you're considering the level at the ground floor, not
Right,
the first floor.
right.
And there's elevations that clearly show that the height.
Thank you.
You're welcome.
Any other questions? No? Anyone else speaking in favor? Anyone else in favor? Is there anyone here opposed? No opposition, okay. Further questions? We're all set? Okay, this hearing is closed.
I make a motion to approve.
Second.
We have a motion to approve and we have a second. Discussion?
I'm in favor of it. It's going to get parking off the street, and it's a good design.
Okay, anything else?
Mr. Chairman, I think that the street affords the home the expansion due to the fact that it borders on the marsh and that there won't be any more construction. I guess it borders on the state park and the marsh there and there, so there won't be any future expansion.
Okay. We have a motion to approve and we had a second on the motion. Mr. Smith.
With the motion.
Mr. Soto.
With the motion.
Ms. Ferranti.
With the motion.
Mr. Montana.
With the motion.
I'm with the motion. It's approved.
Item
You're
number
welcome.
9, I'm sorry. Item number 9, 1201 Boston Post Road, MVP 89/812/40A, SCD, Daniel Sloan, agent for Connecticut Post Limited Partnership, Centennial Real Estate Management owner, varies section 5.18.1, event duration of 14 days to extend duration of operation from 6/1/23 to 9/4/23 for 96 days.
Sorry, I pulled my back. Hi, my name is Erin Sloan, and I'm here representing Funbox, which we have brought to the Connecticut Post Mall. We have received our 2-week TP, and we would like to apply for a variance to extend through Labor Day to continue the fun for the kids in the area.
Just as simple as that, huh? Okay.
Well,
So your permit right now would be to what?
September 4th.
Okay. What is the current one that you have in place, though?
The 15th of June.
Any questions? No? Just an extension of permit? Maybe you can even go to the fun house down there?
I hope so. I might have brought some passes.
Anyway, is there anyone else speaking in favor? Please come forward.
Good evening. Ken Sturba, General Manager of the Connecticut Post Mall. We are very much in favor. They've done a tremendous job, and we're really pleased to see the positive comments we've received on social media from their first weekend. So this has gone even better than we thought, and we just think it's such a great and unique use for the back parking lot at Connecticut Post Mall. Thank you.
Thank you. Okay. Anyone else in favor? Anyone here opposed? No questions? This hearing's closed.
Thank you. And here are some.
Okay, so we need a motion.
I make a motion to approve.
Second.
We have a motion to approve, and we have a second on the motion. Discussion? As you can see, and then we have some good comments that it's helping the Connecticut Post. So in any way we can bring business and have something positive help going on in Milford, that would be great. So, Mr. Montana.
With the motion.
Ms. Ferranti.
With the motion.
Mr. Smith.
With the motion.
Mr. Soda.
With the motion.
I'm with the motion. It's approved.
Thank you very much, folks.
You're welcome.
Item number 10, 66 Erna Avenue, MVP 43/304/17, CDD1, Raymond Payer, agent for Cullen Industries, LLC, owner, varies section 4.1.7.4 to allow an 8-foot fence in the CDD1 zone.
Evening, Mr. Chair, board members, staff, thank you for having me. Again, Raymond Payer, Vice President of Engineering of Westcott and Mapes. We're located at 142 Temple Street in New Haven. With me, I have Christian Colon, Vice President of Colonial Coatings here on behalf of the owner. You may have materials in your folders, but I have a handout. It's a real simple, the application, some photos, and then a condensed version of the plan. I may approach the panel to provide a copy for each. Again, the subject property, 66 Erna Avenue, Colonial Coatings. The application is for a variance of section 4.1.7.4. We're seeking an 8-foot high security fence in a CDD1 zone. The section reads, security fences shall require a special permit to be issued by the Planning and Zoning Board in an HCD, ID, and LI zone. Security fence up to a maximum of 8 foot that does not obscure visibility may be erected along the side, rear property lines, and behind the required front yard setback for the district. Security fences are prohibited in any other zone district. And that's the issue we have, is the fact that this is in a CDD1 zone. It is that type of use, light manufacturing. The equipment that it protects is air handling equipment, ductwork, fans, etc. It's external equipment. It's been on property many years, and this came about such that their operations required to expand and add to that equipment. We wish to add a pad and more equipment. In working with staff in the city, it was looked at such that the fence currently was not, there was not approval in file, and now we seek to relocate and move the fence around a new pad. So I come before you with the vital interest of Colonial Coatings so that we can secure the proposed equipment with meeting all the requirements, 8 foot high, security fence. It will not be in the setbacks. It meets all the requirements except the fact that their business is in the CDD1 zone, which is not listed in the section of the zoning permit. Again, it's vital for their operations. The fence would prevent tampering, vandalism, theft, and security for that equipment. So they do wish to have that in place. What we would do is alter the fence that's out there to meet the requirement and then relocate it even further beyond the new pad and equipment. So on behalf of the client, I respectfully request your consideration for approval for the variance this evening and available to answer any questions you may have.
Yeah, I have a question. Is the new fence it's going to be 8 foot high? And then is there going to be the additional wire on the top, that concertina wire?
The new fence will be 8 foot high, that is correct. We will not be adding the barbed wire atop because that would make it too tall. So the desire is to just have the 8 foot high chain link fence and the other security measures, cameras and such as well, but no concertina wire.
Yeah, okay, because by looking at the picture, the present one, it was kind of turned in, but it was there, so.
Agreed, and we recognize that, and reading the requirements, we will correct that such that it's just the fencing without the wire beyond the 8 foot.
Questions? Go ahead, Mr. Montana.
Mr. Perry, am I correct in stating that the area on Erna and the side streets is about 90% commercial?
You are correct. There are no residents abutting any of the property, and it is primarily commercial, industrial type property.
Thank you.
Any other questions? Anyone else speaking in favor? Anyone here opposed? No further questions? No, this hearing's closed.
I make a motion to approve.
Good. We have a motion to approve in second.
Seconded.
We have a motion to approve. We have a second. Discussion. The discussion would be it's definitely a safety issue,
It's a reasonable
security
request,
issue.
yeah. Definitely.
You know, it's something that's absolutely needed. So, Mr. Montana, your vote, please.
Approve.
Ms. Ferranti.
With the motion.
Mr. Smith.
With the motion.
Mr. Soda.
With the motion.
I'm with the motion. It's approved.
Thank you all. Have a good night.
Thank you. Okay. What do we have next? New business. Any new business? Do we have any old business? Staff update? Staff update? Nothing going on? Applications for next month? Are we going to be as busy next month as?
Just the carryovers, 12 Francis and Hanover.
And there's 2 new ones, and they
and
are
Beach.
surprisingly early, so we may have a big agenda again. I think it will. Yeah.
Is there a
It's a
point where
trend.
you might cut off? Is there a point where you might cut off earlier if you see the agenda's getting too heavy?
No, because applications are driven by statute. So if somebody gives us an application, it has to be on the next regular scheduled meeting, even if there's 20 of them,
As long as they get it in by the deadline, correct?
as long as they get it in by the deadline. Yeah.
All right, so then the only other alternative for us would be a cutoff time if we ever get to that point.
Oh, well, it's already about 3 weeks because of the noticing
I
requirement.
think he meant to authorize the meeting going past a certain hour, the way planning and zoning does.
That's entirely up to the board. The board can look at the agenda and say, no, this is a little bit too heavy for one night, because you have 65 days to open up a hearing. So you're not compelled to open up a hearing just because it's on the agenda, unless you have to open it up. And you don't have to open it up for 65 days if you don't want to.
Okay, so what you're suggesting is, next time we look at it, and if we think it's too heavy, we could comment on it at that time, but then, like Ms. Ferranti just brought up, it's like we have leftovers all the time. It's only going to keep growing, so.
Well, it's
Just trying to figure out what we could do if we ever get into that
Well,
situation.
we don't usually have a lot of carryovers. The past couple of months have been unusual in that respect.
But we've just
So,
been getting
you
a
know,
lot.
my advice would just be to take it each meeting as it comes. If you don't want to go past 10, you simply say, well, we won't go past 10.
And we've also,
But for items that have to be heard, because sometimes there are, might have to rearrange the order of battle on the agenda and hear items that absolutely have to be heard.
I think the other thing that's driving it is the lot certification appeals. There was a window of time when there were several of those, and those are,
We've had 3 in a row.
appeals take longer, as we know.
We've had 3 in a row, so then that's unusual.
Okay, any other business? Motion to adjourn?
Motion to adjourn.
Okay. This meeting is adjourned.